All right, welcome to Module 3, Chapter 6, Construction Contract Provisions. I'm not going to walk through this whole chapter. I'm going to point out some things and as an overview and be able to go into depth a little bit with a couple things. You have a discussion post on indemnification clauses. I will look at the indemnification clauses with you, discuss that a little bit more in detail. But I want to talk in general, a big picture about contracts. And the reason that is the case is because, as the book's going to point out, it can't even begin to teach you in one chapter everything about contracts. I took a whole semester of law school on contracts, and it was just scratching the surface, the very basics of what a contract is to a lawyer. So one of the things that happens is a owner, one of the very first things they have on their team is a lawyer or a staff of lawyers, depending on how big the project is. I know of situations where literally, if you're going to build a construction project, you're going to set aside a certain percentage of money as an owner just for lawyers. The same thing is true if you're the architect or if you're a general contractor. You're going to set aside money for lawyers. And let me explain that process or why that's the case. It's because in construction, things go wrong. Something goes wrong. And a lot of times it's time or money become an issue. And when that happens, it took too long. Why did it take too long? You cost me money. There's a liquidated damages. I have to, the general contractor has to pay so much money per day for every day that the building is not finished. So wait a minute, I got to pay you $10,000 a day because it's not finished. It's not my fault. It's not finished. They're going to find out whose fault it is, and we're going to sue them over the contract. It's going to govern our relationship as to why I'm having to pay $10,000 a day. I have talked with lawyers in the construction world that talk about serious issues. Let's say you build a football stadium. It happens, right? Every few years there's a football stadium built or a college football stadium. But let's think of it like an NFL football stadium. Well, what do you got that has to get built? You have a football stadium, but you're going to put 60 to 80, 100,000 people in that building. So you're going to have to upgrade the water and sewer capacities for their site. You're going to probably have to do off-site improvements to water and sewer systems. You're going to have to maybe run the trains, around DC. Maybe you have to put in a subway stop. Maybe you have to build some highways. Maybe you have to build some off-site parking garages. There's a lot of things that can come into play that become really big factors, and a lot of opportunities for things to go wrong, not be built correctly. And when that happens, everybody turns back to the contract, and they have your lawyers investigate through the contract who did or did not do the work properly. So I know that a football stadium is getting built and all the improvements, and it's like $1 billion. There's going to be 20 to $50 million easily spent in attorney fees. Sounds crazy, but you can have litigation go on for years. Football stadiums open and there's litigation for another 5 to 10 years over whose fault things were. I think it's the Atlanta Falcons football stadium. They have a retractable roof in Georgia. I think that's where it's at. I might be wrong, but I thought it was down there. And the roof was supposed to close in let's just say 30 minutes, and something went wrong and it takes 3 hours. That's not good. If you have a reason to quickly close it, like a lightning storm or something, and it takes 3 hours, well, the storm's gone. So that type of situation, the stadium opened up, obviously it's got a problem, and there's a major lawsuit over, whose fault it is as to how it doesn't open up. So that's the reason for the contracts and the importance of it. When you look at this little diagram on page 169, 6.2, usually you have a prime contractor. The owner will, the single contract system is what 6.1 is. That particular scenario is normal and is the one that is most likely to occur in a project. Very rarely does an owner have multiple prime contractors. I guess it's possible if somebody was doing your site work, or somebody's doing your off-site improvements, to have a different prime contractor than the person who's actually putting up your building. That is a very good possibility of something like that. But you're not going to have a prime electrician. You're not going to have a prime, flooring guy. You're not going to have a prime plumber. You're not going to contract like that with the owner. You're going to generally have one prime contractor who, below them, everything comes into play. So I want to draw your attention now. The book points out Appendix D. So if you want to go ahead and flip all the way back to Appendix D in your book, it is the AIA documents, general conditions of the contract for construction. We're not going to look at every aspect of this, but I want to point out the complexity of a construction contract. I talked to the lawyer for Smecco. Smecco built a building. Smecco, if you're none of you, somebody's not local, Smecco is our local power company here in Southern Maryland. I think they put up a $25–30 million building. And the lawyer that I knew who works for, does a lot of work for Smecco, he said he did not want to handle these documents. And he gave away about $1 million worth of work on a $30 million project. Another company got it. They charged more money for it. And there was lawsuits, and you have an attorney protecting the owner, administering this contract. So, but just look at the table of these articles, the different components of this contract. You have general provisions, things specific to the owners, things specific to a contractor, to an architect, whole sections on subcontractors, construction by owner or by separate contractors. If there's change orders, a whole section on change orders and how you go about changes. If there's a change in work and all the ramifications that come down from that. How time is calculated, and specifically, is time of the essence. And if you can't meet certain deadlines, what's the penalty for it? How you're going to get paid. A whole section on payments. Protection of persons and property. We're going to go back and look at that. The indemnification clauses. Different types of insurance and bonds, and we'll cover some of the bonding and insurances in a later chapter. How about inspections? Number 12, correcting work. If you see something's wrong and somebody else needs to fix something, the whole section covers that. Then if it didn't cover it, there's miscellaneous. Also termination or suspension. For some reason, if this contract has to be terminated or suspended. And some states may have had to suspend contracts during COVID. Maryland was one that continued working in the construction business, but other states, maybe New York, the construction world maybe didn't continue. And you had to suspend your contract because all the different things involving time that couldn't be met any longer. And then if there's any arguing, any claims or disputes over the whole project, there's a whole section on that too. Usually it covers arbitration before you get to the courtroom. So I just wanted to point out the complexity of the construction contract and why the book can't cover everything. And I'm just sort of flipping here for a moment. There's 38 pages that are mentioned here in this sample, and that's not even really realistic in the real world. They're much larger. You can get like a 50, 60 page contract. Not unheard of one bit. So that part of things, I just wanted you to grab an overview of contracts. I wanted to come back now and take a look at, you can sort of glance through the areas of, like, the rights and responsibilities of the owners and the architects and engineers. But I'm going to take a little pause here, take a few minute break yourselves. And when we come back, I'm going to talk about indemnification, which is part of your discussion post this week. Okay. I went and grabbed a book, Black's Law Dictionary. I'm trying to get a feel for it. This thing is huge. It's about 3.5, 4 inches thick, 8.5 by 11 pages. Yeah, something like that. Yep. Good sized book, tons of stuff in it. But I want to read to you. Black's Law is the standard dictionary for lawyers. I'm going to read to you the definitions of indemnification and indemnify. Indemnification. It says the action of compensating for loss or damage sustained. The compensation so made is indemnification. To indemnify, though, is really what you're looking for, because the other is a process, the action of it. So indemnify is to reimburse another for a loss suffered because of a third party's or one's own act or default. Hold harmless is a synonym. To promise to reimburse another for such a loss, and to give security against such a loss. Indemnity is the duty to make good any loss, damage, or liability incurred by another. The right of an injured party to claim reimbursement for its loss, damage, or liability from a person who has such a duty. So why is it that indemnification is such a big deal? And why am I going to focus on it? And why am I going to have you talk about it amongst yourselves? Indemnification is a huge deal. Let's just say somebody is personally injured, like the Hyatt Regency Hotel collapse that we were watching these videos from. Indemnification. So in that particular case with the hotel, you've already figured out that the structural engineer had a lot of blame, a whole lot of blame. But the structural engineer doesn't have all the money that Hyatt has. So these families would want to get reimbursed for their injuries. So they're going to sue the structural engineer. He doesn't have enough money. They're going to go for the deepest pockets and try to get the most responsibility. And they're going to go after the general contractor, and they're going to go after the owner. They're going to go after the architect. Everybody on up the line that has money, they're going to go after them. So indemnification is something where one party agrees to hold the other party harmless and cover the cost for any damages that they may incur from a third party. So you have a situation where, let's say a subcontractor, you're working, the plumbing guys are working in a building, and Usually when you do the building, all of your utilities go in at the same time. One of the last things that goes in is electrical. But let's say you got some electrical in there, you got something going on, plumbing guys are working and one of their plumbers gets electrocuted and dies. And so his family is looking for, her family is looking for all of the damages associated with the wrongful death. So why is indemnification important? So, okay, so we've got a plumbing company, guys working for me or girls working for me. I'm the owner of the plumbing company. So they're going to sue me. Well, I didn't do it. I didn't do anything. We're out there working. We're doing what we're supposed to do. What it turns out is that the electricians came in out of order. They had to get some work done because they had an open window. So they came in and they started doing some work, and some stuff was live that shouldn't have been live, and the plumber hit it, with something, with a torch or something. I don't know, who knows? But the plumber touched it and died. So now it's really the electrical company's fault. All right, but they're still suing me because I'm the plumber. But I'm going to have to join the electric company, electricians, because they're the ones at fault. And I'm going to go after them for anything I lose because it's their fault. And the electrician is going to turn around and say, no, it's not my fault. I had permission from the general contractor to come in this particular way. And in fact, I wasn't negligent. So that you see the argument now. Now you got the electrician calling in the general contractor. Well, guess what? The family whose spouse and father or mother has died, they're already going to sue everybody up the chain. So they're going to sue the company that their spouse or father worked for, mother worked for. They're going to sue that plumbing company. They're going to sue the electricians. They're going to sue the general contractor. They're going to sue the architect, or maybe the mechanical engineer, maybe not the architect, but the mechanical engineer who laid everything out, electrical engineer. All of those people are going to be named right up to the owner. Why? Because they're going after the money trail. They're looking for anybody who was at fault for any of this process. So indemnification comes about with, if you're the electrician, they're going to say the general contractor is going to want you to indemnify them against losses from third parties due to your negligence. Or they're going to try to get a really broad, they're going to try to get you to indemnify them for even their own mistakes. But that means that, so as an electrical company, we would indemnify, we would have a clause in our contract with the general contractor that, hey, if we make a mistake and somebody sues us and a third party also sues you, we will pay your damages that are attributed to our mistake. That's indemnification. It is a big, big deal because who has the most money in all of this? It's the owner. The owner has the most money of every one of these people involved. Lawsuits get back to the owner. The next one to have the most money is the general contractor. They're going to get sued. It is so hard to build any kind of a large project without a lawsuit. And if there's accidents, if people are injured, if property is damaged, let's just say you're putting up the steel building and nobody gets hurt. This happens like on a weekend. Nobody's working. Part of the building collapses and it damages concrete piers. It damages the electrical work, all the subs that had done work, plumbers, electricians, HVAC, ductwork guys, whatever, stuff's damaged, now has to be redone. They're going to look for whose fault it is. Even though nobody was physically injured, there was damage done to property. And because of that, they're going to look to sue someone to recoup what they've lost. At the same time, the general contractor is looking for somebody to cover him or her, because they're like, wait a minute, I'm going to have to pay now. All these people, these trades have to get paid to redo their work. You got to buy more supplies. Who's paying that extra cost? The owner may pick up the tab because they want to get things rolling. They may go ahead and say, okay, we'll pay for all this to be fixed. But in the meantime, I'm going to go sue whoever was responsible for that steel column falling in the corner of that building collapsing. So you have a lot of things going on, and indemnification is where generally where one party protects another party from its own mistakes. So, if I'm the one who makes a mistake, you shouldn't have to pay for my mistake. That's common sense. But when we're going to look here at 3 different types of indemnification clauses, and you're going to see that they're different and that they try to protect different people. The first one is a limited form indemnification. The limited form holds the owner, architect, engineer harmless against claims caused solely by negligence of the prime contractor or subcontractor. Now, that is the one as a subcontractor to people. That's the one I'm willing to do. If I make a mistake, you shouldn't have to pay for my mistake. So that is fine as far as, as a subcontractor, you want that one, but it doesn't do enough for the owner and the architect. They actually would like to have broader indemnification so that there's less likely that they're actually going to have to pay out any damages. Probably the most common one is this one, 2, the intermediate form indemnification. The intermediate form includes not only claims caused by the contractor or its subcontractors, but also those in which the owner and or architect engineer may be jointly responsible, regardless of the degree of fault. It says this is the most prevalent type of indemnification clause, and it is contained in the A1A documents 201, A201 to 2007. So that particular one, the obligation assumed by the contractor, it does not extend to liability arising out of certain acts of the engineer, or architect or engineer. So that there's a little differentiation between, the owner's side of things and the general contractor side. And it doesn't even get into necessarily regardless of the amount of fault. It just sits there as far as being in play. So again, it's not only claims caused by the contractor or subcontractors, but it also is those that are caused by the owner or the architect. Sometimes the owner can cause a problem for the general contractors. And here, this is where you're trying to indemnify the people at the top from one another, trying to limit the liability and exposure from all sides by divvying it up a little bit. The next one is broad form indemnification. Broad form indemnifies the owner and the architect engineer against all losses, even when the party indemnified is solely responsible for the loss. This one you're not going to have happen too often. Basically the owner, it says all losses, so who's at fault sometimes? It could actually be the owner or the architect, and you're still going to indemnify me against those losses. That's not going to work very well. It's too broad. The other thing that happens is you have to watch how you indemnify someone as a subcontractor. So for example, as a surveyor, I have errors and omissions insurance. So if I make a mistake, I have liability for my professional license. If I make a mistake using that license, then it's covered by insurance. Fine. But I do not have insurance to indemnify or defend a general contractor. I get hired by a general contractor, Um, Something goes wrong on the site, I get sued. I'm brought into the suit. Let's just say there's, who knows what it could be, but because surveyors usually don't get sued because of other people, but let's just say we did. Something happened and maybe, oh, I know what it could be. Something happened and they blame my, I don't know, site, something floods or something. And because of the flooding, there's $100,000 bulldozer that no longer can operate and it's damaged beyond repair or something like that. We'll just make something up. So whose fault is it? It could be the person who graded it. It could be the person who staked out the parking lot and we didn't put it at the right grades or something. So you start naming people and you get up to the general contractor. I don't have insurance to pay for the general contractor's lawyer. I don't have insurance to pay for things that are contractually related or things that are not professional liability exercise in my profession with my license. I don't have insurance to pay for that. So a lot of times you get pressured by general contractors to sign their indemnification agreements that protect them the most or you don't get the job. And you have to weigh that out. Is it worth the job or not? So I've turned jobs down, but they didn't let me modify that indemnification to only be my fault and not other people. And I am not going to defend you in the courtroom and pay for your attorneys regardless. I don't have that kind of insurance. So this is a overview. I went into some depth about indemnification because it's, again, it's one of your assignments this week. It's also something that's pretty important, is this whole thing of allocating risk in a contract. That's what lawyers are paid to do. You're paid to allocate as much risk from your client as possible and get other people to assume the risk. And then when you're the contractor and subcontractor, you're doing the same thing. You're trying not to assume as much risk as the owner and architect want to put on you. So I'll take another little break here and we're going to wrap up here pretty quickly. All right, one more little thing that I'm going to speak about here is it's in the book, chapter 6, 6.10. It's liquidated damages. A lot of construction contracts will have liquidated damages in it. Probably most contracts will have liquidated damages. So what is a liquidated damage? It is damages that come about usually because of a delay. So let's say you're the owner of a home, you're the owner of land, you're having a general contractor, home builder, put a new house on it for you. And he says he or she tells you it's going to take 120 days to build your house. And you're like, fine. And you sell your house and you have to rent one now. That's your fault. That's what you have to pay. It's fine. But you get a lease that is only 4 months long, 120 days. And if that contractor does not finish the house in 120 days, as long as it doesn't have a good excuse, like, it rained for 30 straight days, anything like that, COVID, stuff like that, then you're going to have to pay some damages. Now, what are the damages for the homeowner? Well, it would be having to rent a new place, maybe a hotel, maybe having to drive further to work, cost there, time there. Maybe they had furniture, now they have to put it in storage. They had stuff there, their house is supposed to be furnished. Everything's paid for and was going to be delivered in the 120 days. And now they have to store it all someplace. So those things are your damages. However, what I just described are actual damages that could be figured out. And that's what is not liquidated damages. Actual damages that are easily figured out are not liquidated damages. liquidated damages, in order to be enforced by courts, they must be reasonable in nature. And it says, the book says, a reasonable forecast of actual damages, but it also has to be virtually impossible to determine, or really hard to determine the actual damages for something that goes wrong. The liquidated damages clause is supposed to be realistic and keep you from having to figure out something that's really, really hard as to actually what the damages are. Also, the liquidated damages cannot be a penalty. You just can't arbitrarily say you're going to pay me $5,000 a day because you didn't have this done in time. Why? Why is it? Well, just because you should have had it done and you're going to pay $5,000 a day because you didn't have it done. That's a penalty, and courts are generally not going to enforce the penalty. So liquidated damages are important. They're in most construction contracts, and sometimes they're not enforceable. They're definitely enforceable from the general contractor and owner side a lot more than they are from the general contractor and sub-consultants. You can read through the book, sort of browse through things like owner caused delays. There's always a problem, but who caused the problem? If the owner causes a delay, then sometimes the general contractor and the subs can come back on the owner because it should have been finished. And now we have other jobs we can't get to, or we're held up, and we're going to have to struggle or pay overtime or hire more people to go do those other jobs that we should have been doing instead of yours. So there's a lot of things that are involved. You can look at 6.18 acceptance and final payment. You're looking at something that's usually 95% complete or more. You're looking at, how you're going to wrap up, like a punch list of items that need to still be fixed and finished. You're looking at transferring warranties. A lot of little things like that go into a contract. So again, knowing ins and outs of contract for construction law is really difficult. Can't be covered in a half hour or 45 minutes, and certainly cannot be covered in one chapter of this book. If you have any questions about the contracts, I'm free to answer them the best I can. But otherwise, have a good week, and we'll see you for Module 4.